First Amendment. The First Amendment of the Constitution provides citizens freedom of speech. This protection is considered a fundamental right. Content-based restrictions on speech are restrictions that are based solely on the content of the speech itself. It permits or forbids speech based on the message or subject matter being discussed. Content-based restrictions are highly disfavored and therefore must survive strict scrutiny, which means that the government has the burden of proving that the regulation is narrowly tailored to achieve a compelling interest, and it is the least restrictive means of achieving that purpose. Vague and overbroad. Vague regulations on speech are regulations that are ambiguous and don't provide definite standards that allow for citizens to know how to comply with them sufficiently. As such, they are struck down as a violation of the First Amendment. Here, forbidding political signs is impermissibly vague because it does not sufficiently apprise citizens of what kind of signs constitute political signs. It is unclear whether that just pertains to elections, or if it also encompasses political ideology, thought processes, campaign financing, etc. This proposal is unconstitutionally vague and can be struck down on those grounds. Equal protection grounds. The equal protection guaranteed by the federal Constitution prohibits the government from discriminating against a specific class of people and not others. Depending on the class at issue influences what type of scrutiny is employed in analyzing the constitutionality of the regulation. First Amendment time/place/matter restriction. Proposal 2 regulates lighting for any and all sign placed on property. This is likely a permissible time/place/matter regulation. Time/place/matter regulations on speech are ones that are focused on the timing/placement of speech rather than the content/viewpoint of the speech. Time/place/matter restrictions are permissible so long as 1. They are content neutral, 2. Serve an important government interest, and 3. Leave open alternative channels of communication. Said differently, these restrictions are subject to a form intermediate scrutiny. First Amendment, prior restraints. Prior restraints on speech are regulations that prevent or burden speech from happening before it has occurred. Generally speaking, prior restraints on speech are disfavored. Proposal 3 contains a licensing restraint that would require citizens to receive a license prior to installing lighting signs on their property. Prior restraints may be upheld so long as the standards for the restraints contain definite standards and don't allow for unfettered discretion in its application. Definite standards require that precise procedures be followed so that the people/public officials issuing the licenses do not have any room to exercise discretion in deciding whether to issue the license. Procedural due process. The federal Constitution provides, under the Fifth Amendment, that all persons are not to be intentionally deprived of life, liberty, and property without the due process of law. This provision is applicable to the states via the 14th Amendment. Procedural due process requires that individuals, prior to being deprived of any rights, are entitled to notice, a hearing in front of a neutral magistrate, and the right to be heard prior to being deprived of any of their constitutional rights. Taking. Under the Takings Clause of the Constitution, any individual who is deprived of their property by the government is entitled to reasonable compensation. Individuals are entitled to notice before their property is taken for public use. Under the Takings Clause, a person can be deprived of their property if the government either 1. Physically takes up a portion, or all, of their property, or 2. Regulates the property to such an extent that the property does not retain any economic value. Standing. The plaintiff has standing to bring this claim. In the United States and in Florida, an individual must have standing in order to bring a claim to challenge the constitutionality of a government action. The Constitution of the United States provides that U.S. courts are only permitted to hear cases and controversies. In order for a claim to be a case or controversy, the plaintiff bringing the claim must have standing. Under Lujan v. Defenders of Wildlife, to have standing, a plaintiff must have suffered an actual or imminent injury. An actual injury is one that is concrete and not imagined. An imminent injury is one that is sure to happen, not just merely possible. The plaintiff's injury must be causally connected to the government's action. There must, therefore, be a causal chain linking the plaintiff's injury directly to the government's action. Finally, the plaintiff's injury must be redressable. A favorable ruling from the court must cure plaintiff's injury. Taxing and spending. DUPA is a proper exercise of Congress's power to tax and spend. Article 1 of the Constitution provides for the plenary power of the United States Congress. Among these powers is the power to tax and spend for the general welfare. The Congress of the United States is thus afforded plenary, or nearly absolute, power to levy taxes from the states in order to raise revenue for actions that are rationally related to the general welfare. Furthermore, Congress is permitted to spend money from the federal treasury in order to provide for the general welfare. Congress's spending power also extends to its power to allocate funds to the several states to serve the general welfare in the states. While Congress is prohibited from commandeering state resources or instrumentalities, see below, Congress, under its spending power, is permitted to condition spending on states' adherence to government initiatives. However, all of Congress's powers are subject to laws against discrimination, as will be explained below. Commerce. DUPA is a proper exercise of Congress's commerce power. Like its taxing and spending power, Congress has a near-plenary power to regulate interstate commerce in the United States under the Commerce Clause of Article 1. This includes the power of Congress to set limitations on the use of commerce and the means and instrumentalities of interstate commerce that are rationally related to a legitimate government purpose. Means and instrumentalities of interstate commerce include roads, waterways, and vehicles. In addition to regulating interstate commerce itself, the Commerce Clause also permits Congress to regulate non-commercial activities that substantially impact interstate commerce in the aggregate. However, all of Congress's powers are subject to laws against discrimination, as will be explained below. Equal protection. DUPA violates the Equal Protection Clause of the 14th Amendment, incorporated to the United States government by the 5th Amendment. The 14th Amendment to the United States Constitution, which was passed in response to the abolition of slavery and Jim Crow in the United States, is written and intended to abolish discrimination based on who a person is. While the 14th Amendment explicitly targets the states and not the federal government, the Supreme Court has ruled that the 14th Amendment Equal Protection Clause is applicable to the federal government by way of the Due Process Clause of the 5th Amendment, which applies specifically to the federal government. The Equal Protection Clause of the 14th Amendment provides that every United States citizen is to be permitted equal protection of the laws. The Supreme Court has identified several classes of persons who are afforded special protection because of their membership in the class, and therefore, laws that discriminate against persons based on this class status are given heightened scrutiny when reviewed by the courts for constitutionality. Laws that unequally impact persons based on race, national origin, or alienage are given strict scrutiny. Strict scrutiny provides that the government must prove that the law is necessary to achieve a compelling governmental interest and narrowly tailored to achieve that interest. Strict scrutiny is an incredibly high bar, and laws are usually struck down under strict scrutiny. Laws that unequally impact persons based on gender and illegitimacy are given intermediate scrutiny. 21. Intermediate scrutiny provides that the government must prove that the law is substantially related to an important government interest. Finally, all other laws that target persons based on class status are given rational basis review. Under rational basis review, the challenger of the law must prove that the law is not rationally related to a legitimate government interest. This is an incredibly low bar for the government, and laws reviewed under rational basis are generally upheld. Due process. DUPA violates the Due Process Clause of the 5th Amendment. The Due Process Clause of the 5th Amendment provides that the federal government may not deprive U.S. citizens of life, liberty, or property without due process of law. Due process of law has been defined as the process that is due, which generally includes notice and a hearing before the termination of rights. The Supreme Court of the United States has identified two types of due process, substantive and procedural. Procedural due process provides that the government may not deprive persons of life, liberty, or property without due process of law. Citizens have property rights to public jobs, benefits, and licenses. Substantive due process provides that a person may not be deprived of a fundamental right without due process of law. Fundamental rights include the right to vote, the right to free speech, the right to privacy, and the right to interstate travel. The right to privacy includes the rights to contraception, abortion, marriage, procreation, education of children, and child-rearing. Substantive due process violations are analyzed under strict scrutiny, so the government must prove that the law is necessary to achieve a compelling state interest and narrowly tailored to that interest. Police powers. DUPA violates the principles of federalism. Federalism provides that the powers of government in the United States are to be divided between the states and the federal government. The states are not to encroach on the federal government's power, e.g. the Supremacy Clause makes federal laws supreme over state laws, and the federal government is not to encroach on the state's power, e.g. the 10th Amendment gives all powers not specifically assigned to the federal government to the states. States, not the federal government, have police powers. This means that states are afforded the sole power of legislating for the general health, welfare, and safety of their citizens. The state's police power generally includes the rights of states to provide for education, criminal laws, police, firefighting, licensure, etc. Anti-commandeering. Furthermore, under federalism principles, the federal government may not commandeer the instrumentalities of the states. In other words, the federal government may not utilize their legislatures or agencies to enforce a federal law. This rule was developed by the Supreme Court in the case of Brady, where the federal government tried to force 24 states to use their police forces to conduct background checks on potential gun owners in order to enforce a federal gun regulation. Standing. Standing requires 1. Injury in fact, 2. Causation, and 3. Redressability. Injury in fact requires a particularized injury, one that affects the plaintiff in an individual way, and a concrete injury, one that exists in fact. Causation requires a causal connection between the injury and the complaint of conduct. Redressability requires a showing that a decision in the plaintiff's favor will be capable of remedying her grievance. First Amendment. The First Amendment protects the right to freedom of speech and press. Regulations that infringe on this right are often unconstitutional unless they fall into a category of speech that the government can regulate, i.e., false commercial speech, fighting words, obscenity, etc., or survive strict scrutiny. The government can show that the regulation is necessary to achieve a compelling state purpose. The government can regulate the conduct associated with speech with reasonable time, place, and manner restrictions. If the restriction applies in a public forum or a designated public forum, to be valid, the restriction must be content neutral and substantially related to an important government interest. If the restriction applies in a non-public forum or a limited public forum, to be valid, it must be viewpoint neutral and reasonably related to a legitimate government interest. In addition to regulation of conduct, the government can regulate content. However, content-based restrictions are presumptively unconstitutional. To be valid, a content-based restriction must be necessary to serve a compelling state purpose and narrowly tailored to achieve that purpose. Content-neutral regulations, on the other hand, must be substantially related to a legitimate government purpose and leave open alternative means of communication. Overbroad. A law is overbroad under the First Amendment when it punishes both protected and unprotected speech in its plainly legitimate sweep. Equal protection. The Equal Protection Clause prohibits discrimination on the basis of classifications. Where a law discriminates on the basis of a suspect classification, strict scrutiny is applied. The government must show that the law is necessary to achieve a compelling state interest. Where a law discriminates on the basis of a quasi-suspect classification, gender and illegitimacy, intermediate scrutiny is applied. The government must show that the law is substantially related to an important government purpose. Where the law discriminates on the basis of a non-suspect classification, such as age or wealth, rational basis applies. The challenger must prove the law is not rationally related to a legitimate government purpose. Spending power. The government is not prohibited from spending government funds on faith-based schools so long as the government's spending is made not only to faith-based schools, the spending is not for the purpose of inhibiting or advancing religion, and the government is not entangled with the religion. For example, it is permissible for the government to provide books to faith-based schools as part of a program where books are provided to all schools, regardless of faith or secular nature. Sixth Amendment right to counsel. The Sixth Amendment right to counsel attaches when the defendant is formally charged and prohibits officers from communicating with the defendant without counsel present. The Sixth Amendment is offense-specific. Defendant has a right to have counsel present at every critical stage of the case. Once the defendant is appointed an attorney, officers and agents of the officer are prohibited from communicating with the defendant to elicit incriminating responses from him. The right to counsel must be invoked by the defendant and may be waived if the defendant communicates. The defendant had counsel and could have been said to invoke the right to counsel. First Amendment. Content-based restriction on speech. The First Amendment of the Constitution provides citizens freedom of speech. This protection is considered a fundamental right. Content-based restrictions on speech are restrictions that are based solely on the content of the speech itself. It permits or forbids speech based on the message or subject matter being discussed. Content-based restrictions are highly disfavored and therefore must survive strict scrutiny, which means that the government has the burden of proving that the regulation is narrowly tailored to achieve a compelling interest, and it is the least restrictive means of achieving that purpose. Vague and overbroad. Vague regulations on speech are regulations that are ambiguous and don't provide definite standards that allow for citizens to know how to comply with them sufficiently. As such, they are struck down as a violation of the First Amendment. Here, forbidding political signs is impermissibly vague because it does not sufficiently apprise citizens of what kind of signs 31 constitute political signs. It is unclear whether that just pertains to elections, or if it also encompasses political ideology, thought processes, campaign financing, etc. This proposal is unconstitutionally vague and can be struck down on those grounds. Equal protection grounds. The equal protection guaranteed by the federal Constitution prohibits the government from discriminating against a specific class of people and not others. Depending on the class at issue influences what type of scrutiny is employed in analyzing the constitutionality of the regulation. First Amendment. Permissible time/place/manner restriction. Proposal 2 regulates lighting for any and all sign placed on property. This is likely a permissible time/place/manner regulation. Time/place/manner regulations on speech are ones that are focused on the timing/placement of speech rather than the content/viewpoint of the speech. Time/place/manner restrictions are permissible so long as 1. They are content neutral, 2. Serve an important government interest, and 3. Leave open alternative channels of communication. Said differently, these restrictions are subject to a form intermediate scrutiny. Prior restraints. Prior restraints on speech are regulations that prevent or burden speech from happening before it has occurred. Generally speaking, prior restraints on speech are disfavored. Proposal 3 contains a licensing restraint that would require citizens to receive a license prior to installing lighting signs on their property. Prior restraints may be upheld so long as the standards for the restraints contain definite standards and don't allow for unfettered discretion in its application. Definite standards require that precise procedures be followed so that the people/public officials issuing the licenses do not have any room to exercise discretion in deciding whether to issue the license. Procedural due process. The federal Constitution provides, under the Fifth Amendment, that all persons are not to be intentionally deprived of life, liberty, and property without the due process of law. This provision is applicable to the states via the 14th Amendment. Procedural due process requires that individuals, prior to being deprived of any rights, are entitled to notice, a hearing in front of a neutral magistrate, and the right to be heard prior to being deprived of any of their constitutional rights. Taking. Under the Takings Clause of the Constitution, any individual who is deprived of their property by the government is entitled to reasonable compensation. Individuals are entitled to notice before their property is taken for public use. Under the Takings Clause, a person can be deprived of their property if the government either 1. Physically takes up a portion, or all, of their property, or 2. Regulates the property to such an extent that the property does not retain any economic value. Forfeiture. The government could argue that this enforcement provision is a constitutional forfeiture. A forfeiture allows for the government to obtain an individual's property without notifying them prior to taking the property, if the government believes that the property is being used in furtherance of a criminal act. Standing. The first issue is whether TAB has standing. Standing requires injury in fact, i.e. a particularized, specific injury that is not suffered by the population at large, but rather, is unique to the plaintiffs, causation, and redressability, i.e. that a decision in the plaintiff's favor would actually rectify the harm/injury. An organization can sue on behalf of its members if individual members could, in their own right, bring the claim, if the claim is related to the organization's purpose, etc. Injury need not be economic. Injury/harm can occur when a fundamental right is suppressed. Sovereign immunity. Although TAB's challenges are federal, it is suing based on the Seaside Ordinances. Time/place/manner restrictions. Parks are designated public forums, i.e. areas which historically have been open for speech-related activities. Sidewalks and streets are also examples of typical public forums. Given the history of speech associated with such places, parks are open to the community, free access, etc. The government can only place restrictions on speech if certain tests are met. Speech-related laws/ordinances can be content 18-based or conduct-based. If they are content-based, they must pass strict scrutiny. The government has the burden of proving there is an important/compelling government interest, and that the ordinance is narrowly tailored, i.e. the least restrictive means of achieving the goal. This is a heavy burden to meet. If, however, the regulation is merely conduct-based, and is regulating the time, place, or manner, TPM, of speech, without regard to the actual content, a different test is used. For a conduct regulation of speech in a public forum, the law must be 1. Content neutral, i.e. both viewpoint and subject matter neutral. 2. Narrowly tailored. 3. Leave open alternative channels of communication. Note: for non-public and designated public forums, the test is even less strict. The law merely must be viewpoint neutral and be rationally related to a legitimate interest. Unprotected speech. Speech that is likely to incite imminent lawless activity is not protected. However, prior restraints are strongly disfavored. Vagueness. A vague law is one which doesn't provide fair notice, i.e. that a person of average intelligence would not be able to clearly understand what is permitted and what is prohibited. Overboard. Overbreadth means it sweeps in a substantial amount of protected speech in addition to unprotected speech. Equal protection clause. When the state regulates a suspect class, strict scrutiny is applied. Standing. In a constitutional forum, the plaintiffs must show that they have standing to sue. Standing is an actual injury or threat of an injury that is concrete and particularized and not speculative or hypothetical. They must show that there was causation for the violation of their rights flowing from the state actor which impacted their exercise of a protected right. Finally, they must also show that a favorable ruling would lead to a redressable result, that it would do something to cure the violation. First Amendment. The U.S. and FL constitutions both protect the right to freedom of speech and association as protected expression. These rights are deemed to be fundamental to our citizens' pursuit of ordered liberty. They are among the most fundamental of any of our rights, and as such are protected by a strict scrutiny analysis whenever there is any infringement on such speech. Speech is regulatable, and there can be legal and other consequences for speech. This is not directly prohibited by the Constitution. However, any infringements on the right are subject to rigorous review. When speech takes place in a public forum, such as a park or sidewalk, or another area traditionally held open to the public for speech and associational activities, any regulation on protected speech must be a valid time, place, or manner restriction, without the intent to suppress speech. When the restriction is content-based or viewpoint-based, this triggers a strict scrutiny analysis. When people are engaging in protected, as a non-illegal or a lesser protected category of speech such as obscenity, any government action that suppresses the speech will be analyzed under strict scrutiny. To survive a strict scrutiny challenge, the government must show that they have a compelling governmental interest, which they brought into effect with a narrowly tailored act that was the least restrictive means. With speech, this means that they must leave open alternative channels of dialogue and not act to suppress speech. Any challenge to a constitutional right inflicted by a governmental actor, such as the police, is protected, whereas private persons are not bound to respect the constitutional rights of others in such a strict manner. Sovereign immunity. The state of FL may sue, through its Attorney General, for relief from unconstitutional legislation. To prevail, they must have standing and also assert a cognizable case against the government. The government is not immune from suits by the states in federal court, and the proper forum for an action between the state of FL and the United States would be the U.S. Supreme Court, who has original jurisdiction under the Constitution to hear a case between a state and the federal government. Any legislation that is constitutional at the federal level and conflicts with state legislation preempts the state legislation to the extent of any conflict. Federal acts which require a state to enact legislation may be unconstitutional as a commandeering of a state legislature to act. This is because of the protections of federalism in the U.S. Constitution, which prohibit the federal government from requiring states to enact legislation. However, the feds may condition certain funding on the passage of constitutional legislation. The U.S. Constitution requires standing, in addition to having a live case and controversy, to allow a federal court to adjudicate the action. Bicameralism. Legislation of the United States works similarly to state legislation. There must be bicameralism, which means that the bill must originate in one house and pass in both houses by a simple majority. Additionally, there must be presentment, where the passed bill is presented to the president for signature. A president may choose to sign or veto a bill, and in the event of a veto, the Congress may repass the legislation over the president's veto by a 2/3 majority. Legislation that has not passed by one of these two methods is not current and enforceable legislation. Equal protection. Equal protection. The federal government is restricted by the U.S. Constitution, its amendments, and federal court cases that have interpreted the Constitution. Through the 14th Amendment to the United States Constitution, there is a prohibition on the states from depriving any citizen of the due process of laws. This applies to both procedural acts of the government and also substantive protections of fundamental rights guaranteed by the Constitution. When the government acts to discriminate or restrict a fundamental right with regard to all citizens, this potentially violates substantive due process protections. Where the government seeks to act on the basis of a suspect classification such as race, religion, or national origin, the legislation must meet strict scrutiny, as detailed above. When the government seeks to treat people disparately on the basis of a quasi-suspect classification, such as gender or legitimacy, the act must survive intermediate scrutiny. This level of review requires the government to show that they have an important government interest, and that the restriction or action is substantially related to bringing this into effect. While the 14th Amendment Due Process Clause facially only applies to states, federal jurisprudence has interpreted it to also be applicable to the federal government, with regard to the same protections that the Fifth Amendment guarantees. Commandeering Clause. The federal Constitution contains an explicit prohibition from the federal government ordering a state to pass legislation by command of the federal government. The idea is that this implicates the implicit separation of powers between the federal government and states, known as federalism. When federal legislation requires a state to pass laws, they are unconstitutional. However, the federal government may legislate to clarify that states do have certain authority if it stops short of a command. Additionally, if such an act is an enablement and not a command to legislate, the federal government may validly condition certain discretionary funding given to the states through the taxing and spending powers of the U.S. government in Article I of the Constitution, but they may not act wholly coercively. First Amendment. The First Amendment protected the freedom of speech. Economic speech, such as advertisements, has long been recognized as protected. In fact, many of the cases addressing this issue in the 11th Circuit involve the Florida bar and attorney advertising. Advertising that is inherently false and misleading, however, is not protected speech, that is, under a First Amendment analysis, may be prohibited completely. All other regulations of commercial speech must meet intermediate scrutiny, which means that the government interest at issue must be important and the law narrowly tailored to achieve those ends, as opposed to strict scrutiny for speech generally, which would be that the government interest is compelling and the law necessary and the least restrictive means to achieve that interest. The court cannot inject its own reasons into the analysis, rather, it must assess the law based on the reasons provided or reasonably articulated by the legislature. The government bears the burden to establish the importance of the interest and the narrow tailoring of the law to that interest. The statute here likely fails on all accounts. While false or misleading claims in advertising are regulatable and may be completely prohibited, the legislature has not advanced that all or even most or even some significant percentage of out-of-state advertising regarding citrus is false or misleading. That is, prohibiting false or misleading advertising is permissible. But the government has neither established based on the reason it proffers that there is any such interest here at play, because it bases the statute on merely some examples of false or misleading advertising. At the very least, even if that interest were found to be important in this context, the law is not all properly tailored to achieve its purposes. The legislature could simply have banned and/or fined all actually false or misleading advertising. The second reason provided economic protectionism by providing in-state citrus growers a competitive advantage is not considered an important governmental interest capable of supporting an abridgment of free speech in the First Amendment context. Client therefore has very strong grounds to challenge the statute as a prospective violation of its commercial speech. Privileges and Immunities Clause. Privileges and Immunities Clause, because it seeks to discriminate or distinguish on the basis of in versus out-of-state residence on the issue of economic activity/livelihood. States may not discriminate on the basis of state residence absent a compelling and legitimate governmental interest and if the mechanism employed is narrowly tailored and required to achieve that end. Commerce Clause. The federal Constitution empowers Congress and the federal government to regulate commerce between the several states, between the U.S. and foreign states and between the U.S. and Native American tribes. There is no indication in the facts here that the federal government has spoken directly to the issue of advertising in the citrus space, although, common knowledge would implicate the Supremacy Clause as well, which provides that federal law is supreme vis contrary state law, or state law requiring abridgment of the federal law, where the federal law is in an area properly within federal power to act, such as, here, regulating interstate commerce, as the FDCA and other federal statutes clearly govern the space, rendering the statute invalid for attempting to regulate an area governed by federal law. Regardless, a state statute implicates the Commerce Clause even where 12 the federal government has not spoken, i.e., the Dormant Commerce Clause, because it seeks to regulate interstate commerce and distinguishes on the basis of state residency/in versus out of state. A state statute violates the Dormant Commerce Clause in such a context if it fails to meet the rigorous strict scrutiny test discussed above. And as discussed above, economic protectionism, at least where the state itself is not preferring in-state businesses, is not a compelling interest. Neither is the false advertising issue compelling here, as it is not properly tailored. Contracts Clause. The federal Constitution prohibits a state from passing a law abrogating private contract rights. However, to fall afoul of the Contracts Clause, the contract needs to be in existence. A state law is not violative if it prevents the realization of future and not yet existent contracts. Equal protection. Laws that categorize and provide differential treatment on the basis of those categorizations are suspect. However, laws that categorize on economic basis, for example, laws that non-licensed doctors cannot practice medicine, are subject only to rational basis review that the law serves some justifiable governmental purpose and that the law be reasonably or rationally related to achieving that purpose, with the burden on the plaintiff, not the government, as was above. Standing. In order to have standing, a plaintiff must show an injury in fact. The injury must be actual and imminent, and not just speculative. Additionally, the injury must be one that is capable of redress by the courts. A third party can bring the claims of another when that injured person, for some reason, is incapable of bringing the claim on their own, or if the claim is one that is capable of repetition yet evading review. Government action. Under the federal Constitution, in order for an individual to assert that their rights have been violated under the 14th Amendment, they must show that their rights have been violated by a state actor, as the 14th Amendment does not protect the violation of rights by private actors. As a public school, John can argue that the school is an agent of the state, and that his rights have been violated by government employees. Just because a government provides funding for a school does not automatically implicate them as government actors. The question is how involved the state is with the school, and if they are advancing the school's denial of certain rights or simply taking a neutral stance to it. First Amendment rights. Under the federal Constitution, the First Amendment grants citizens the freedom of speech, which is a basic and fundamental right to the Constitution. This freedom is not absolute. The Constitution does not protect hate speech. The government has the power to regulate certain forms of speech, such as imminent lawless action, fighting words, obscenity, defamation, and commercial speech. Those are categories of speech that are not protected by the First Amendment, and that the government is free to regulate. Normally, any restriction on a person's freedom of speech that is based on the person's expressive conduct is judged under the standard of strict scrutiny. Strict scrutiny means that in order for a law to be found constitutional, it must be narrowly tailored to a compelling state interest and be the least restrictive means possible. In analyzing whether a breach of a person's freedom of expression has taken place, it is necessary to first evaluate where the speech has taken place. Case law has drawn a distinction between public areas, which are known and historically popular for being a place where people express themselves, such as at a park, or a courthouse, where citizens are afforded the most protection under the Constitution. There are also non-public areas, such as someone's front lawn, and there are also semi-public areas, such as government buildings like the IRS. In public areas, the government has the right to implement certain time, place, and manner restrictions. These restrictions must be content neutral and must be substantially related to an important government interest. They need not be the least restrictive means and must leave open alternative forums for the expression to take place. Content neutral restriction. While content-based rules will be measured under strict scrutiny, rules that are content neutral and apply to everyone the same across the board no matter what type of expression is being regulated, will only be judged by a standard of rational basis, and will only be struck down if it is ambiguous or arbitrary. A law passes the rational basis test if it is rationally related to a legitimate government interest. The burden is on the challenger in this instance, as opposed to strict scrutiny, where the burden is on the government. Vague/overbroad. As opposed to strict scrutiny, where the burden is on the government. A law is vague when it does not provide people with notice of what behavior is prohibited by the law, and a law is overbroad if it prohibits more speech than necessary to achieve its goal. Intentional infliction of emotional distress. In order to have a claim for intentional infliction of emotional distress, a plaintiff must prove that the defendant's intentional or reckless outrageous behavior caused the plaintiff extreme emotional distress. Outrageous behavior is behavior that is so outrageous that it goes beyond all bounds of common decency. This is judged by an objective standard. Although IIED is an intentional tort, the defendant can be guilty of it if he was reckless, meaning that he acted with a conscious disregard that his behavior would produce a certain result. Although the plaintiff need not prove physical injury, he does need to prove that there has been some manifestation of the distress. It is not enough that the plaintiff sometimes has difficulty sleeping or as a result of the incident, he can't focus or concentrate. Torts of their children. Under common law, a parent is not liable for the torts of their children. But, a parent can be found guilty of negligence directly attributed to them if they have a duty to watch over their children and fail to, or if they are aware of their child's dangerous propensities and fail to warn people of them or to protect others from them. Mr. Smith would have to prove that the parents had a duty to supervise the child, that they breached this duty, that the breach of this duty was the actual and proximate cause of his injury, and also that he suffered damages.